Okay, I'm going to read an outline in another tab. Testing. Oh my gosh. Testing. Still working? Testing. Are we still working? Just testing. Okay. All right, so this is going to be an essay writing approach for civil procedure, just some preliminary considerations and issues that generally don't make any sense to me. Starting with the scope of the rules. Applicants should be prepared to answer questions out of issues concerning the Federal Rules of Civil Procedure and the California Code of Civil Procedure. Applicants should be prepared to discuss the differences between federal rules and California rules, especially those California procedures of pleadings and practice that have no specific counterparts in the federal rules. State Bar of California, Committee of Bar Examiners, Office of Admission. Interrogatories drive the essay issues and answers. So I never understand this part. It just gives you sample questions. Like an example of one would be, was the federal court correct to deny CopyCo's motion for change of venue? Discuss. A, is Sally entitled to a copy of the maintenance records? Discuss. If so, how must she proceed to obtain them? Discuss. Is CopyCo entitled to an order to compel Sally to appear for an examination by a physician and an examination by a psychologist chosen by CopyCo? Discuss. And if so, how must it proceed to obtain such an order? Discuss. And then there's another example. I just don't know why they're called interrogatories. Anyway, the issue checklist to follow is Part 1, proper court, Part 2, governing law, Part 3, pleadings, Part 4, parties and claims, Part 5, discovery, Part 6, pretrial motions, Part 7, jury trial, Part 8, final judgment, Part 9, res judicata, and collateral estoppel. Next page. Here's the civil procedure rule summary. I don't remember seeing something so short. Oh my gosh. Okay, so Civ Pro is going to be different than the other essay outlines that I've gone through because it's got a really short rule outline, and then it's got a couple pages of more, 1, 2, 3, maybe 6 to 8 pages of outline here. Oh my God, more like 8 or 9. So let's just get through this short rule summary, and then hopefully we dive into the full outline for preparing to write essays about inquiring about civil procedure. It also is asking us to view the lecture for California civil procedure for California rules. So for Part 1, does the court have the authority to decide the dispute? Subpart A, does the court have authority over the parties? 1, personal jurisdiction. Traditional ways of asserting jurisdiction are domicile, presence in state where served, and consent. Part B, under personal jurisdiction, is assertion of jurisdiction over non-residents. 1, the long-arm statutes. A, unlimited and limited or specific, or 2 types of long-arm statutes. 2, under the assertion of jurisdiction over non-residents is constitutional limitations, contacts and notice. A, minimum contacts arise from purposeful availment in the stream of commerce cases and internet cases, and also foreseeability under which is Part 2 under the minimum contacts principle. The next principle under contacts and notice within constitutional limitations is the relatedness of the claim to the contact. And then there's lastly fairness. So within constitutional limitations, you've got minimum context, relatedness of the claim to the contact, and fairness, traditional notions of fair play and substantial justice. So for relatedness, this is part B of constitutional limitations, context and notice. Relatedness of the claim to the contact. Specific jurisdiction, claim arising from the activity in the state, whereas general jurisdiction is the defendant is at home in this, in quotations. Individual is, quote, at home, end quote, in state of domicile. Part B under general jurisdiction, the corporate defendant is, quote, at home in states in which it has a principal place of business and is incorporated. Next part under these constitutional limits is fairness. Traditional notions of fair play and substantial justice is the key term. For convenience, part 1 under fairness, A, need not be the best alternative. B, form acceptable unless it is so gravely difficult and inconvenient that a party is unfairly put at a severe disadvantage. 2 under fairness is the forum state's interest, providing redress for its citizens. 3 under fairness is other factors, starting with A, plaintiff's interest in obtaining convenient and effective relief. B, interstate judicial system's interest in efficiency. C, shared interests of states. D, notice, service of process. And lastly, 2 under fairness. So I think it's under fairness, unless it's an alternate to personal jurisdiction altogether, which I think is actually correct because 2 reads in rem and quasi-in rem cases, dash, the same constitutional analysis applies as in personal jurisdiction. Which again, under personal jurisdiction, the traditional ways of asserting jurisdiction was domicile, presence in state where served, and consent. And remember that assertion of jurisdiction over non-residents first involves the long arm statutes and those constitutional limitations of context and notice, which is your minimum context, relatedness of the claim to the contact, and fairness involving convenience, forum state's interest, and those other crazy factors, which is the plaintiff's interest, the judicial system interest, and the shared interest of the state. So that's it for this short civil procedure rule summary of whether the court has authority to decide the dispute. So the next outline is a, quote, IPJ sample template. IPJ. I mean, personal jurisdiction is your PJ. I don't know what I stands for. So that throws me. But anyway, for personal jurisdiction in this, quote, template, first paragraph being personal jurisdiction, you've got insert your issue statement. In personam. Okay, in personam jurisdiction, IPJ, refers to the court's ability to exercise power over a particular defendant. Traditionally, IPJ is based upon where the individual party is domiciled, presence in the state when served, and consent. Here, for example, defendant lives in state X and thus not domiciled in state Y, the forum state. Additionally, he was not served in the state, nor did he consent to IPJ, thus no traditional basis for IPJ exists. Long-arm statute. Since no traditional basis exists, the plaintiff must look to see if the state has a long-arm statute that would allow IPJ over the defendant, since a federal court must analyze IPJ as if it were a state court in the forum state. It will use a long-arm statute to determine whether it has IPJ. A long-arm statute gives the court personal jurisdiction over a defendant. Some state statutes, like California's long-arm statute, give court the power over any person over whom the state can constitutionally exercise jurisdiction. Other states have statutes that list specific instances when the court may exercise IPJ over the defendant here, blah, blah, blah. Insert the analysis. Constitutional limitations. Even if the state statute arguably grants the state court in personam jurisdiction over the defendant, such exercise must still be constitutional. To be constitutional, there must be sufficient contacts with the forum state so as to not offend traditional notions of fair play and substantial justice. The United States Supreme Court has listed a series of factors with which to assess the constitutionality of IPJ. In general, the factors fall under 3 headings: contacts, relatedness, and fairness. If IPJ is a major issue, then organize this as follows. Minimum contacts. Minimum contacts requires a showing of purposeful availment and foreseeability. Purposeful availment, the court must find that defendant purposefully availed itself of the privilege of conducting activities in the forum state, thus invoking the benefits and protections of its laws here, fill in the analysis. Foreseeability, the defendant also must have known or reasonably anticipated that its activities in the forum rendered it foreseeable that it may be hailed into court there, here, fill in the analysis. Relatedness of the claim to the contact. If the claim arises from the defendant's contacts with the forum, the court may have specific jurisdiction. In parentheses, it says personal jurisdiction over the defendant only for the plaintiff's instant case of action. End paren. The close connection between the cause of action and the contact will likely make the exercise of IPJ fair and reasonable. Regardless of whether the plaintiff's claim is related to the defendant's contacts with the forum, the court also may have general jurisdiction, which is in quotes, not in quotes, in parens, personal jurisdiction over the defendant for all causes of action, end quote, end paren, and the defendant, if the defendant is, quote, at home, end quote, in the jurisdiction. If there is no relationship between the plaintiff's claim and the defendant's contacts with the forum, the court must have general personal jurisdiction over the defendant to hear the case. Okay, next page. Specific jurisdiction claim related to defendant's contacts. For specific jurisdiction, the claim must be related to the defendant's contacts with the forum state. Here, insert analysis here of the specific facts that support this element. General jurisdiction, in paren, quote, at home, end quote, jurisdiction, end paren. As stated above, the court also may look to see if the defendant is, quote, at home, end quote, in the forum, and thus able to exercise general personal jurisdiction over the defendant. If there is no specific personal jurisdiction, the court must have general personal jurisdiction to hear the case. The Supreme Court has stated that, as paradigms, a corporate defendant is, quote, at home in the state in which it has its principal place of business or in which it is incorporated. An individual is at home where he is domiciled. Here, insert analysis here of the specific facts that support this element, end paren. Fairness. This court, in determining whether exercising IPJ over defendant is fair, will look at the convenience to the defendant, the state's interest, and other factors. However, fairness is not a consideration if the court is exercising general personal jurisdiction over the defendant. Convenience. A forum is constitutionally acceptable unless it is so gravely difficult and inconvenient that the defendant is put at a severe disadvantage. Here, insert analysis here of the specific facts that support this element. End paren. State's interest. The forum state may have a legitimate interest in providing redress for its residents. Here, insert analysis here of the specific facts that support this element. End paren. Next section, next paragraph, other factors. These are all headings, by the way. I'm going to read all the headings up to where I am. Personal jurisdiction is a heading, long arm statute is a heading, constitutional limitations is a heading. All these subheadings under constitutional limitations is minimum contacts, purposeful availment, foreseeability, relatedness to the claim to the contact, specific jurisdiction claim related to the defendant's contacts, general jurisdiction, at home, which is at home jurisdiction, and then fairness, convenience, state's interest, other factors, minimum context. If IPJ is not a major issue, we will actually minimum context. We come back to minimum context in the context that IPJ is not a major issue. So finally, the last heading when IPJ is a major issue is state interest and then other factors. So for the state interest, I think I said that already. You would begin that paragraph of analysis with the forum state may have a legitimate interest in providing redress for its residents. Here, insert the analysis of the specific facts that support this element, and then other factors. Start that paragraph with other factors include the plaintiff's interests, the judicial system's interests, and the shared interests of the states. Here, insert analysis here of the specific facts that support this element. In conclusion, the factors more strongly support a finding that IPJ exists over the defendant, and thus the court's ruling to deny the defendant's motion to dismiss for personal or lack of personal jurisdiction was proper. If IPJ is not a major issue, then we're going to do something a little bit different. So here's minimum context and how you would begin that paragraph, which is interesting because it's longer. Minimum context requires showing that purposeful availment and foreseeability. Okay. Minimum context requires showing of purposeful availment and foreseeability, period. The courts must find that defendant purposefully availed herself of the privilege of conducting activities in the forum state, thus invoking the benefits and protections of its laws. Additionally, the defendant must have foreseen that she would have been hailed into court in the forum state. Here, now use specific facts to quickly analyze these two factors. All right, so what that means is instead of breaking the two factors into two separate subheadings, we mush them all together. Relatedness of claim to contact is the next subheading when IPJ is not a major issue. Specific jurisdiction exists where the claim is related to the defendant's contact with the forum. General jurisdiction exists when the defendant is at home in the forum. The Supreme Court has held that as paradigms, a corporate defendant is at home in the states in which it has a principal place of business and in which it was incorporated. Here, now use specific facts to quickly analyze these two factors. Fairness. The court, in determining whether exercising IPJ over defendant is fair, will look at the convenience to the defendant, the state's interest, and other factors. Fairness is not a consideration if there is only general personal jurisdiction over the defendant. Here, now use specific facts to quickly analyze these two factors. All right, so that was all part A, actually. Now we're entering some part B, still within part Roman numeral 1. So for subpart B, the heading is, does the court have authority over the subject matter? 1, subject matter jurisdiction. And B, A, state courts are generally courts of unlimited jurisdiction. B, federal courts have jurisdiction over only two types of claims. Federal questions. Complaint must show a right or interest founded substantially on a federal law. That's your federal question jurisdiction. Diversity actions. Diversity of citizenship and amount in controversy. For diversity, the action must be between citizens of different states. There's two different subparts under diversity, for the natural person and for the corporation. For the natural person, citizenship is a state of her domicile. Domicile is established by two factors, presence in state and intent to make it her permanent home. For a corporation, citizenship equals every state where incorporated and the one state where the corporation has its principal place of business. Amount in controversy. Part B of diversity actions is 1 and 2, 1, plaintiff's good faith allegation must exceed $75,000, not counting interest or costs. And part 2, aggregation of claims. Plaintiff can aggregate claims against one defendant, joint tortfeasors, value of the claim, and equitable relief, either plaintiff or defendant's viewpoint. So those are the 3, A, B, and C, under aggregation of claims. I'm just going to read them again because they don't seem like super related. So under aggregation of claims, A, plaintiff can aggregate claims against one defendant. Got that. But B, joint tortfeasors dash value of claim is all that you have under B. Under C, there's equitable relief, either plaintiff or defendant's viewpoint. I don't quite know what they mean there. But anyway, there's removal jurisdiction and supplemental jurisdiction. Also under subject matter jurisdiction. So for letter C, removal jurisdiction only from state to federal court. And then part D, supplemental jurisdiction, requires a common nucleus of operative fact. Subpart C, within part Roman numeral 1, is the court the proper place to resolve the dispute? Number 1, venue in federal courts. A, district where any defendant resides if all defendants are residents of the state in which the district is located. B, where a substantial part of the claim arose or substantial part of the property is situated. Or C, if no district satisfies A or B, a district in which any defendant is subject to the court's personal jurisdiction with respect to such action. And D, improper or inappropriate venue results in 1 or 2, a transfer or forum non-convenes. Now, I think we're in part D. No, we're in part 2 now. Roman numeral 2. What law governs this dispute? For letter A within part 2, this is a short part. You see Erie Doctrine. This is the only letter under subpart 2. For the Erie Doctrine, there's only 2 numbers. 1, federal courts are required to apply state substantive law to non-federal causes of action. And number 2, the necessary and proper clause allows federal courts to apply federal procedural rules. In addition, federal courts will apply some state procedural rules when those rules have no bearing on the mechanics of the federal court system. Roman numeral 3, part 3, are the pleadings proper? Part A, federal courts use notice pleading. Part B, complaint. Part C, defendant's response. Part D, counterclaim. Part E, cross claims. Part F, amendments and supplemental pleadings. And Part G, Rule 11. So this will all be pretty quick and short. Federal courts use notice pleading. Part A, the pleading must put the opposing party on notice of the claim. By contrast, some states use code pleading, which is not California. Actually, I don't even know what I'm talking about. B, under part 3, complaint, 1, 2, and 3, statement of subject matter jurisdiction, 2, statement of the claim, and 3, demand for relief. C, part C, defendant's response. 1, answer must contain specific denials or admissions of each averment or a general denial with specific admissions. Must also contain affirmative defenses. Answer is due within 21 days after service, 60 days after request for waiver was mailed if service by mail and waived formal service. If denial of a 12B motion, then 14 days to answer after denial. Court has discretion to allow the state filing of an answer. Late filing of an answer. Rule 12 motion, watch waivable defenses. Now moving to letter D, under subpart 3, are the pleadings proper? D is about counterclaims, compulsory, permissive, and supplemental jurisdiction is available if needed for compulsory. Letter E under section 3 is cross-claims, supplemental jurisdiction is available if needed. Letter F, amendments and supplemental proceedings, that's actually all that's given. And letter G, Rule 11, discussing certifications and sanctions. Part 4, Roman numeral 4, are the proper parties and claims before the court. A, joinder of parties. 1, compulsory joinder. A, absent parties should be joined if possible. Absent parties should be joined when 1, complete relief cannot be accorded in the party's absence, or 2, absentee has such an interest in the subject matter that a decision in his absence will either A, impair or impede his ability to protect the interest, or B, leave another party subject to substantial risk of multiple or inconsistent obligations. Next page. B, absent party can and must be joined if the court has personal jurisdiction over the absentee and the absentee's presence would not destroy subject matter jurisdiction or venue. C, if joinder is necessary party is not feasible, for example, would destroy diversity jurisdiction, the court must either proceed without the absentee or dismiss the case. If dismissed, call the absentee indispensable. In determining whether to proceed or dismiss, court will consider 4 things. 1, extent of prejudice to absentee or available parties. 2, extent to which such prejudice can be reduced or avoided. 3, adequacy of a judgment rendered without the absence. And 4, whether absentee will have an adequate remedy. 2, permissive joinder can be joined as plaintiff or defendant if the same series of occurrences or transactions and a common question of fact or law among the parties exists. Letter B under part 4, which I believe had to do with joining parties, or what was it? Are the proper parties and claims before the court, because there's also claim joinder, but really party joinder is the main topical area. Although arguably this next section, part B, joinder of claims, is pretty long. So for class actions is what's discussed in 1, intervention 2, and then in pleader I think is 3. Class actions, 2-step process for analyzing issue. Step 1, initial requirements met. Step 2, is it one of the 3 types of suits allowed? Initial requirements. It's super weird. It's just weird. It's weird how they have step 1 and step 2, but then A relates to step 1 and B relates to step 2. So for initial requirements met, let's go with the initial requirements. Are 1, class is so numerous that joinder of all members is impracticable. 2, questions of law or fact common to the class. 3, the claims of the representative parties are typical of the class. And 4, the representative parties will fairly and adequately protect the interests of the class. So that's the 4-part initial requirements. Numerosity, common issue or question of law. If the representatives are going to fairly represent everyone in the class and protect the interests of the class. Oh, typicality. That was 3. 3 is typicality and 4 has to do with the representative. So numerosity, common issue, question of law, typicality, and representative parties are going to fairly and adequately protect the interests of the class. Now, the types. Step 2 is the class action one of the 3 types of suits allowed? This apparently is a federal requirement, not a California requirement. Easy way to remember the elements: you can't sue in a class action, so can't. stupid. I'm sorry. The three types of class action suits are prejudice, and is number 1. 2 is injunction and declaratory judgment, and declaratory judgment, and 3 is common question predominates. Those are the 3 types of class action suits: prejudice, injunction / declaratory judgment, and common question predominates. Back to step 1, the mnemonic can't means commonality, adequate and fair representation, numerosity, and typicality, which went over in step 1 if the initial requirements are met. So you got to meet both of those in the class action, and that's looking like all we have to analyze for class actions, at least in federal court. It's not talking about the class action like fairness statute that reduces these requirements a little bit, on the context of diversity, but in an amount dispute, but it's fine. It's really not important. Intervention is part 2 under joinder of claims. Let's move on to intervention, impleader, and interpleader. So for intervention, A, intervention is a right, permissive intervention, and C, supplemental jurisdiction if needed for intervention of right or defendant, but no restrictions on the use. Impleader, indemnity or contribution is what impleader usually relates to. B, other claims, third-party defendant versus plaintiff, and plaintiff versus third-party defendant. And C, supplemental jurisdiction if needed for impleader and third-party defendant versus plaintiff, but no restrictions on the use exist. Interpleader, there's a Rule 22 interpleader and a statutory interpleader. Something tells me that's it. Yeah, that's kind of it. You just need to kind of know the rules. Like, for instance, just reference Rule 22 there. Got my note card so that I can analyze that. It comes up in one of the sample essays we're going to answer soon. Part 5, Roman numeral 5, have the parties properly propounded and replied to discovery. So you have 3 subsections here. A is types of discovery, B is the scope of discovery, and C is enforcement of the discovery rules by sanction. So for the types of discovery, you have depositions, interrogatories, requests to produce physical or mental examinations, requests for admission, and required disclosures. I might argue that there's like an initial, and I might argue we've got a meet and confer requirement that should be included here, and privileges probably ought to be discussed, but maybe that's in the scope of discovery. Anything relevant to the claim or defense of any party. 2, privilege matter is not discoverable. 3, work product, and 4, discovery must be proportional to the needs of the case. I might say something about ESI, electronic stored information, I believe. And then subpart C in this discovery topic is enforcement of discovery rules by sanction. Total or partial failure to provide discovery can be rectified by a motion to compel plus costs and certifying good faith attempted to obtain discovery. 2, sanctions include A, treat matters as admitted. B, disallow evidence on an issue. C, establish the issue adverse to the violating party. D, strike the pleadings. E, dismiss the case of cause of action or the entire action for bad faith, failure to comply with discovery. and enter a default judgment, again, bad faith. And G, the last one, hold in contempt, except for refusal to submit to physical or mental exam. Again, well. And lastly, 3, within enforcement and discovery rules is the immediate or automatic sanction. Subpart 6, Roman numeral 6, can the dispute be resolved without a trial? Pretrial adjudication is another way to refer to that, I think. Failure to state a claim under Rule 12b-6 is letter A under pretrial adjudication. Letter B is the dismissal, which can be voluntary or involuntary. Part C, the summary judgment, involves 1 and 2. 1, the moving party must show that there is no triable issue of fact and entitled to judgment as a matter of law, and 2, partial summary judgment can be granted. Subpart Roman numeral 7, if there is a trial, who will decide the matter? The 7th Amendment under letter A involves 1, 2, and 3. 1, guarantees. The 7th Amendment guarantees a right to a jury trial for actions at common law, but not for equitable sanctions. State constitutional provisions and statutes also guarantee jury trials. You have to make a written demand for a jury trial. I thought it could be oral, but I guess I'm wrong. And 3, when an action contains legal and equitable claims, legal claim tried first to a jury in federal court. In California, it's opposite. Verdict. The verdict can be a general verdict, a special verdict, or a general verdict with interrogatories. C, if there is a jury, can the jury be disregarded? 1, non-suit. 2, judgment as a matter of law. 3, renewed motion for judgment as a matter of law. And 4, motion for new trial. Roman numeral 8, can the decision be appealed? A, the final judgment rule. 1 and 2. 1 requires final judgment of the entire case before an appeal may be taken. 2, exceptions to the final judgment rule are A, B, and C. A, pretrial orders involving temporary remedies, which is like temporary restraining order or preliminary injunction. B, final judgment on collateral matters. C, interlocutory orders of great importance that may be determinative of the ultimate decision. Part B under Roman numeral 8 is appeals must be made within 30 days from entry of judgment. Part 9, Roman numeral 9, hopefully this is the last section, and it looks like it is because it's after the trial. The question that you're asking is the decision binding in future cases, and what last we have to discuss is A, B, and C. A and B is res judicata, which is claim preclusion, and B is collateral estoppel, which stands for issue preclusion, and last 2 is bound by the judgment. I'm going to go into that first. Parties are bound. Privies to parties are also bound, including those who control the litigation and will be affected by the outcome. Strangers are not bound, but may take advantage of collateral estoppel if jurisdiction rejects mutuality doctrine. And for other jurisdictions, the Constitution requires that full faith and credit be given to public acts, records, and judicial proceedings of sister states. Federal statutes compel recognition of federal court judgments. B, full faith and credit is required only when the court had personal jurisdiction over the parties and the court issued a final judgment on the merits. And C, full faith and credit is not required for foreign country judgments. So res judicata, claim preclusion, there's 4 parts to this. When there is a final judgment on the merits, res judicata prevents reassertion of the claimant's cause of action if there was a final judgment on the merits, the same parties, the same claims, and the claim was actually litigated or could have been litigated. On the merits, end quote, is any judgment except one based on jurisdiction, venue, or indispensable parties, or if first court said it was not on merits. Same parties to the same configuration, P versus D, and then D versus P is not res judicata, but claim could be barred because it could have been a compulsory counterclaim, another issue to consider. And the same claims, this involves the same cause of action. So for collateral estoppel, which is issue preclusion, there's 3 things to consider. First, issues of fact actually litigated and essential to the judgment in the first action are conclusive in a subsequent, although different, action between the plaintiff and defendant or their privities. Default and consent judgments do not involve litigation of the merits and therefore do not give rise to collateral estoppel and can be used as a sword modernly and as a shield traditionally. So what does that mean? There's such thing as non-mutual offense and defense, which means that an issue that led to a judgment in favor of the plaintiff is being used in a second lawsuit against the same defendant. That's offensively using an issue to try to, or a determination on an issue to try to impose on the defendant, more losses, but for like a different party, I believe. And then defensive would be I don't know, maybe I'm wrong. But notwithstanding, in California, which I have open on my screen, I'm just gonna read. California, however, follows the primary rights doctrine. Under the primary rights doctrine, there is a separate cause of action for each right invaded. So, personal injuries and property damage arising from the same transaction occurrence are separate causes of action under the California's preclusion law. So, basically, in claim preclusion, re judicata, under federal law, the majority rule is that is determined by the transactional test. The claim is all rights to relief arising from a transaction or occurrence. However, in California, they call it primary rights, but it's more like the effects test, where it's not so much a transactional occurrence, it's the injuries or damages that are being sought. If those are the same as the first suit, then the second suit may be precluded. I'm just going to end this. I don't think there's a way to make that less confusing.